Well, we've certainly seen a long record of asylum seeker policies challenged in the High Court. In fact, many of those challenges have been successful. We saw, for example, refugee activists striking down in the High Court the Malaysian plan. We've also seen the High Court extend fair trial rights, fair hearing rights to asylum seekers on Christmas Island. So there's certainly a basis there to say that this also might be looked at by the High Court. But in my view, this is going to be less likely to be struck down, and that's for the simple reason that since the Malaysian case occurred, the Federal Parliament has changed the Migration Act, and it's changed it in a way that gives the government a bigger discretion, less checks and balances, and that means it's going to be a harder road in the High Court. What the Migration Act did say is that Australia could not send asylum seekers to other countries unless that other country had sufficient human rights protections in place, that also they had mechanisms to determine their basis for protection, whether they were in fact genuine refugees. That's now been stripped away after that Malaysian decision, and what we have instead is a discretion in the hands of the Minister, where there's only one criterion, and that is, does the Minister think that this is in the national interest to send the asylum seekers elsewhere? There's no reference whatsoever to the need to process them, except that's something that be taken into account. It's not required in the other country. There's no reference to their broader human rights protections, and it's specifically designed to insulate this type of decision from High Court attack. That's not to say there's no chance in the High Court, but certainly this change to the Migration Act makes the odds of a successful challenge far less likely. I think that this plan does treat people arriving by boat differently from those arriving by plane, and that does seem to breach the fact that the Convention doesn't allow discrimination between people as to the means or lawfulness of their arrival. There's also suggestions that it might breach the Convention because of the way they'll be treated in Papua New Guinea. So there's certainly a credible argument that there's a breach, but that's not enough to get you into the High Court of Australia. International conventions can't be argued within our courts. They need to be separately implemented within Australian legislation. That's happened in the Migration Act. And so the real focus here in any challenge won't be on the Refugee Convention directly, but on how that convention is actually played out through that Migration Act. There is one way that the government could head off any High Court challenge to the PNG plan, and that's by having Parliament specifically authorise that plan to change the Migration Act so that that act says that the plan can go ahead even if it does breach the Refugee Convention. That's a big ask, though, to have Parliament to do that. It would mean walking away from our international obligations under that convention, but that's a price that Parliament and the government may have to pay if they want to avoid any prospect of this being challenged in the High Court.